All right, I got a pretty good one. My name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue Gold Law Enforcement Training, bringing you another roadside chat. All right, this one is the officer says, I've been working on an investigation where the defendant was taken into custody relatively quickly. Based on information for the incident, I had probable cause to believe there was evidence of the crime on his cell phone. While I was awaiting the receipt of the phone from a nearby agency because another party had the phone and went to the next state over to go get it. So anyway, the defendant obtained legal counsel before I was able to ask for the phone PIN. Now I have a warrant for the phone, and my agency has the ability to extract the data from the phone, but it could take a very long time. It could cause complications with the phone, et cetera, et cetera. Now, in this case, I would perceive that speaking to the defendant without his attorney would not be intrusion of his constitutional right by applying the logic that I would be asking for a key to unlock something that is secured just like a house or a safe. That being said, I'm concerned that this logic would not apply to electronic devices, and there may be precedents that I'm not aware of. For the time being, I seek the cooperation of the defense attorney. All right. So there's a few moving parts here, okay? There are some cases on this. I'll try to get you a few of those, and you to put them in the description box and so forth. But the first thing is, all right, so what about him invoking his right to counsel? Well, okay, right, he has the right to do that. But, the next thing is, okay, so he's kind of off limits, right? He, under the Miranda, you're not supposed to ask him any questions that could elicit an incriminating response. Could the password incriminate him? Of course, right? Because, when you find that evidence on the phone and then you try to prove in court, like, hey, he's the one with the password, that's going to incriminate him. Now, the next thing is, should we look at this password as no different than the key to a home? And the answer is going to be no, okay? This is a debate, okay? There's a split of authority on this. Some courts view passwords almost, they call it a foregone conclusion. If you have PC for the phone, and you especially if you kind of like know what's in the phone, then it's a foregone conclusion, that the password. How's that logic? I don't know. It's kind of weird, quite frankly. I don't buy it. I don't, quite frankly, kind of understand it. I think it's just maybe judicial gymnastics to try to get around, Fifth Amendment issues. But I think that, if you have to think about it, then the Fifth Amendment applies, right? I mean, that's really as simple as it gets. If you have to use your mental faculties, right, to utter something, to give a statement, to give testimony, right, and that testimony can hurt you, then that is going to implicate the Fifth Amendment, the right against self-incrimination. And calling this, foregone conclusion, or equating it to just like a key to the house is not really helpful, because Miranda does not apply to keys to houses, right? That is a physical evidence. It applies to what's in your brain. I mean, I'll just give you an example. There was a case where the person was under arrest for DUI. They were taken into custody. They were transported to the jail. Then they were asked to do field sobriety tests at the jail. Okay, fine. Maybe it was snowing out. The tests, the part of the test where they had to think, I think Romberg, right, where they had to think about the 30 seconds, that part was thrown out because they had to use their brain to give an answer, right? Whether or not they counted for 30 seconds. So the point is, anytime you use your mind to produce testimony, then the Miranda applies. Now, I got good news and I got some bad news, right? The bad news is that I think if you are going to that person and you're going to kind of like ignore the fact that they have an attorney present, and we can talk about that too. There's other issues that we can address there, but let's say it was a valid invocation, it's effective, it's unambiguous, and the fact that they have an attorney, that they got an attorney, doesn't answer the question, did they unambiguously invoke the right to attorney? I think the answer is probably yes. But you ask them anyway what the code is, and they give you the code. You're not going to lose any evidence. You're not going to lose any evidence. The reason why is because as long as you did not coerce them into giving you that answer, then you're never going to lose any physical evidence from that Miranda violation. but you just can't use their statement into court, right? So the prosecutor would have to know that that statement, that code was gotten in violation of Miranda. But the actual civil right, you gotta be careful. The procedural issue, it's not really a civil right. Miranda's not a civil right, okay? You gotta be careful there. But the due process violation and so forth would only occur, right? The Fifth Amendment violation would only occur if we actually use that statement against them in court. So as long as we don't use that statement, we're fine. And we don't lose physical evidence because Miranda is not applied to the actual evidence found because of an alleged Miranda violation. So, should you ask them for the code? Hey, you have to make your decisions, right? I can't make them for you. If I was on scene or I was in charge, I would, weigh it all out. Maybe talk to my prosecutor and say, hey, this is what I want to do. I know, we're not going to lose any physical evidence. I won't lose the phone. But, do you have a problem with this? And if they probably will, quite frankly, because they don't want to endorse this probably. But push comes to shove, it can be done. Okay? Okay. So my answer to you at the end of the day is that passwords in your brain are not like keys to a house. They are testimony. Comply with Miranda, or have an exception like this, physical evidence exception, and we go from there. I hope this makes sense. If it doesn't, please let me know in the comments below. If you like what we're doing around here, like, subscribe, share with your friends, and until next time, my friends, you stay safe.